you. Um, Hello, everyone. Um, as you all probably know, for the last couple of years now, I've been addressing periodically your group and sometimes individual realty companies. I've been as far away as Huntington, trying to help with clearing up some issues when you're first signing people up, either on a listing or on a contract, to alert you to certain problem areas that if you know about them, you can prepare for them and make it a lot easier on everybody, especially yourself, when you come up on closing. We spent a lot of time with you on sales from estates and things like that. Today, I'd like to talk to you about three areas that, if you're aware of them and you know they can be problematic, that you can try to take some affirmative action going in. The first one would be sales of property that have been acquired from a tax sale. And then the second one would be sales of property using a power of attorney. And the last one would be sales of property that's owned by a trust. I'll do all three of these and then open it up for questions at the end. The first one would be sales of property from a tax sale. You have to realize that these are very, very difficult. Typically, if someone comes up to you and says, "Hey, I just bought some property at a tax sale. I got a great deal. I've got my deed now from the state auditor's office or whatever," or "I know someone who bought it at a tax sale a couple of years ago, and they've sold it, and now the person who has it wants me to list it." I want to alert you that the odds are actually considerably less than 50-50 under that scenario that would ever close. You need to be extremely alert to that. Watch out for them. They are usually big problems. What you have is you have a very long timeline on sales of property that are out of a tax sale. Someone does not pay their property taxes. The next year, the sheriff sells it at the tax sale over at the courthouse. Sometimes hundreds, sometimes thousands of properties are sold very rapidly over there for non-payment of taxes. The problem is people, they know that they've got to wait, and they wait a year and a half, and they get their deed. They think, well, I have a deed and it's recorded, surely I own it now. The problems are just beginning at that point, and you need to be aware of that. It's a long period of time before a sale out of tax property is going to happen. You may put a lot of time and a lot of effort into it, only to find that you can't get anyone to certify the title, or the rug is pulled out from under you at the last minute. I'm typically a positive person when it comes to titles and real estate. I'm rarely this negative, but there's probably nothing as problematic as property gained at a tax sale, and you need to be aware of that. What is the rub on that? What's the problem? There's a number of steps you go through to finally get good title, but beyond that, there's one critical step that can really undo you. I'll give you an example. Suppose someone came to you and said, "Don't worry, this is out of a tax sale, but it was a long time ago. The taxes that were unpaid on this were the 2014 taxes." You would know immediately it's probably the title is not going to be certifiable yet. I know that sounds amazing, but it's true. Timeline is, I'm going to give you an example. Suppose someone did not pay the taxes in 2013. That's when they would start to be good now. In 2014, the sheriff would have sold it at a sale. You would have had to have waited a year and a half for the people who lost it to come in and redeem it. They would be noticed and given a couple of opportunities to come in and pay the back taxes and pay any kind of fees and pay interest to the people who bought it at the sale, etc. So it would be 2016. They would get a deed and they would think, "I'm good. I'm going to go see the realtor. I've got my deed. I've got good title. I'm going to sell this property." No, they're not. Um, the problem is that there's further law that says that you have up to 3 years after you get that deed. Someone can come in and set aside the sale. They can come in and ask the court to set aside the sale. For 3 years, they can do that. The problem is the courts almost always set the sale aside, almost always. The problem is that courts, as far as we can tell, judges simply are reluctant to see a person who may be elderly or does not understand. They're reluctant to see them lose their property over non-payment of taxes. I guess the judges feel that by the time they pay the hundreds or sometimes thousands of dollars to redeem the property and pay all the back taxes, pay the person who bought it interest on the money that they've been paying on those taxes, perhaps pay an attorney to do a title exam and tell the auditor who is to be given notice of the deed, the forthcoming deed, et cetera, et cetera. We think the judges simply are, they feel they've been punished more than enough. And most of the time, I'm hesitant to say all, but almost all of the time, the court will set the sale aside. Typically, title insurance companies, and we know lenders almost always want title insurance now, they will tell you that they can only live with that if it's within the 3-year period, if either A, the person who now owns it has gone to the person who lost it for non-payment of taxes and gotten a quit claim deed from them. Why in the world would someone quit claim away their property? They're already mad enough. They lost it for non-payment of taxes. You know what they're going to say when you go to them and say, hey, I'm sorry you lost your property at the sale, but I don't want you to go to court and try to get it back. Would you give me a quit claim deed? You know they're going to want to be paid and possibly paid handsomely for that. So that's a problem. The second thing that'll solve it for the title insurance companies is if you file a lawsuit to clear title, what's called a suit to quiet title in the circuit court. You go on in, you lay out before the judge that all the notices were given, time has gone by, you have your deed. 3 years hasn't gone by yet, but will the court go ahead and sign a court order that you have good quiet title, you have good title, and that the person who lost it did receive adequate notice, they have nothing to complain about, they're going to let you keep the property. That's expensive and time consuming. Most people don't want to do that, although we are starting to see some people who routinely buy property at tax sales. If they think they've got a good deal going, they will go ahead and bite the bullet, pay the money, and go down and try to get a court order that they have quiet title. But under my scenario, if those taxes weren't paid in 13, sold at the sheriff's sale in 14, you got a deed in 16. If you wait the full year or 3 years, it was clear up in 2019 before you knew that title was good. So we finally hit here in 2020 or maybe late 19, we finally have come to a point where someone would certify that title and you could get title insurance. I hated tax sales so much when I was in private practice. If I heard one was coming, I would invent some reason why I had a conflict of interest and send it on to another attorney. I wanted nothing to do with them because I knew they were nothing but trouble and they're just a bomb waiting to go off. I can give you an example of how the title insurance companies feel about it. If you do not get a quitclaim deed and you do not get a suit to quiet title and you're within the 3-year statute of limitations after you got the deed, the title companies will make us put in the title insurance company the following exception. In the many, many years I've been practicing real estate law, I consider this the worst, strongest, hairiest exception you could ever see in a title insurance policy. It is a deal killer. That exception says that they will not insure as to any loss, claim, or failure of title related to any irregularities, failure to give proper notice, or due process, defects arising from or connected with the sale of, and then they put in the address of the property you're trying to sell on a certain date on a deed from the West Virginia State Auditor to so-and-so. Man, you're talking about a lack of notice. You're talking like lack of due process. That means that's constitutional. That's state of West Virginia Constitution. That's federal Constitution. A circuit judge, you can see why they're afraid of them and why they set them aside. Any lender who sees that in their title policy will not make the loan. They will not accept that policy. So when you are approached for someone who asks you, do they want to list with you some handy dandy property they got at a tax sale a couple of years ago, you want to be aware that you can take the listing and maybe get it under contract, but you're probably going to wind up with a title examination that gives a result that's disappointing to you and the lender, and you're out. Now, if it's a cash sale, just depends on whether the purchaser wants title examination or not. If they get one, most any attorney is going to have the same type of language in a title letter saying, we guarantee nothing until 3 years are gone. This is so strong. I'll give you an example. In the state of Michigan, where there's other reasons this has come back to life, the state bar does not want any attorney in Michigan to certify title out of a tax sale for 20 years. That's how bad many people feel about these. And so you need to be aware of that. I mean, there's a lot of people buying property at tax sales and trying to resell it. You need to be aware of that tough situation you're in if you accept that listing and put it under contract. The next two are a lot brighter than that, I promise you. The next one is you will often be notified by people that, hey, I'm selling this property. I hold a power of attorney for someone, or I know someone who has a power of attorney. They've approached me and they want to sell some property. That's not so bad. You just need to be aware of some simple rules that are going to be there whenever you're trying to sell property or under contract under a power of attorney. First of all, don't do anything until you demand to see the power of attorney. Don't let them say, oh, I've got one. I promise I do. I know I can find it. It's in mom and dad's stuff somewhere. And I've got their power of attorney, and they're up in assisted living now, but I know I have one. Or don't fall for any of that. Insist that you see the power of attorney, or you may be wasting your time. The power of attorney has to be signed, of course. It has to be acknowledged before a notary public. Then the power of attorney should be recorded prior to the closing, the original, or at least the original brought to closing for recording. You can bet that when the title's done, that will be a requirement. Either get the attorney or whoever's doing it that power of attorney to record if it's not recorded, or maybe they want to see the original in advance and bring it to the closing. Without it, you're dead in the water. Now, the power of attorney not only has to be signed and acknowledged, the power of attorney, you need to look at it and make sure it works for your deal. The power of attorney must authorize the person holding the power of attorney, who is called the attorney in fact, to sell real property. Usually, if they're well drafted, they will say, you can sell my real estate, you can execute and deliver contracts, deeds, closing documents, things like that for the closing. You need to look at the power of attorney and make sure, can I really can this person do this? Does this say they can do that? Now, we get into the whole issue of durability too. It used to be, coming down from common law England, that a power of attorney was automatically revoked if the person became incompetent or got under a disability. That was nonsense. That was the law. Heck, that's when you need a power of attorney the most, is when you can't manage your own affairs. But believe it or not, power of attorney was automatically revoked if you got yourself in that situation. Fortunately, we now have the Uniform Power of Attorney Act. West Virginia has passed that law several years ago. Most states have it now. It's standardized powers of attorney, and it said that powers of attorney are now durable. You used to have to put in your power of attorney. It's durable. It is not automatically revoked if I become incompetent or whatever. Under the West Virginia and all the now under the Uniform Power of Attorney Act, they are automatically durable. They survive your incompetency. unless you specifically say they're not, they are durable. That's critical. You don't have to say it anymore. They're durable unless you say they're not. That is critical because let's face it, when people are signing powers of attorney, they may well be doing that because they feel that the day is coming when they're going to need somebody else to go take care of this situation for them. Um, where we get into where it gets interesting, and we struggle with it here sometimes, is it says if you become under a disability, it's still there. The Uniform Power of Attorney Act says that that includes becoming incompetent, etc. And it also says disability includes subsequent incarceration, which means that now you think, oh, come on, Bob, how often am I going to really be dealing with someone where someone is in prison? Lots. There's a tremendous percentage of our population in America now incarcerated. And from what, if you read the newspaper or listen to the news, more of them well on their way all the time. So you need to be aware of that we do have the Uniform Power of Attorney Act, and it says that if someone is subsequently, that's the critical word, subsequently incarcerated, that power of attorney is still in effect. It's still good. It's not a disability that bars the power of attorney. However, if they are already incarcerated and you think you'll just bop on up to the prison in Fayette County and go in the visiting room, and we've had realtors tell us they were going to do that, and we had to disabuse them of that notion. Going up there and get a power of attorney signed is not any good. They are already a prisoner. That doesn't count. But if you can get them to sign the power of attorney before they go to prison, and I'm not being sarcastic here, believe me, sometimes that's when people start thinking about selling real estate. If you can get your power of attorney, a subsequent incarceration does not bar the power of attorney. But don't wait until they're already imprisoned and then think you can go get one. And like I said, you may think this may never happen to you. It happens all the time. And we run into it here more often than you think, where someone is in prison, or we think they're about to go to prison, or they might go to prison, or whatever. We had one here not too long ago that his misdeed was first-degree murder. So it really happens, and it happens more than you think. So you need to be cautious when people tell you they're going to try to work with you to sell some property under a power of attorney. Look at it. Don't go along and let them lead you. Oh, I'll get it to you. I'll get it to you. And then you get right up on closing and they don't have one, or they can't find the original. Then you're in bad shape, because by then the person who they say they have the power of attorney from may be to a point where they are not competent to sign a legal document. They can't do it. And now you can't get the power of attorney. And then you're having to go to court and get court orders and everything else to sell that property. If I can go back just a moment to an incarcerated person, West Virginia Code does provide that if someone is incarcerated, and this is not the sarcastic term the legislature used, it's legitimate, they are considered a, quote, protected person. They are not able to make their own decisions. We've got them in prison. They don't know all the facts. So, but they can still sell real estate, but it's in sort of like going to court when you have a kid, when you have a child. You got to go get someone appointed, got to go get a court order. The court will appoint a special, have a hearing. You'll probably, as a realtor, be asked to testify or at least give an affidavit. This is a fair price. There'll be a guardian ad litem or someone appointed to check into this. The court can sign an order appointing a special commissioner or someone to sign the deed. So then an incarcerated person can sell, but that's not under a power of attorney. That's a special judicial provision. The third thing you might be one aware of, and you see this a lot anymore too, is property being sold out of trust. We struggle with this here a lot, and you probably do too. People come up to you and they say, I've got this property. Then you look into it and you find, no, they don't. It's in trust. It isn't their property. It's in trust. Maybe in trust and they're the beneficiary. Maybe they are the trustee, but the property is being held by a trust. Okay, we see more and more of these. Why? Because for the same reason we see more and more other problem areas with what we do here and what you do. America's getting older. More and more people are hiring elder specialist attorneys, and they write special needs trusts and other trusts like that all the time to protect people, sometimes trying to protect their property from Medicaid taking the property, etc. You've heard all that. So there's a lot of trust. There's trust being written. There's trust being put in wills. It's happening more and more. When someone approaches you and says, I am the trustee, I want to sell this property, kind of like your reaction should be the same thing with the power of attorney. You should think, I'll believe it when I see it. Make them show you the trust. If it's in a will, go to the courthouse if you have to, read the will, make them show you the will. If it's a separate document, trust, look at the trust, find out what's going on. We will have to either record the original trust, unless it's in a recorded will, or record what's called a memorandum of trust. A lot of people don't want to go to the courthouse and record the entire trust. It tells all the world all their business. It tells them that there were 3 kids. 2 of them got left their property, but the 3rd kid was, shall we say, like to spend a lot of time out at Monte Carlo Casino or something, because mom and dad left his part or her part in a trust. A lot of people don't like to spread everything in the world over at the courthouse, stuff like that. They are allowed to file a memorandum of trust. A memorandum of trust is just what it sounds like. It's a condensed version of the trust, which tells people like me enough when we're searching the title that there really is a trust and this trustee can sell this property. A memorandum of trust must be signed by the trustee or by the person creating the trust. It has to be acknowledged before a notary so we can record that memorandum. It has to name the person creating the trust, the name of the trust, the date of the trust, the names of the current trustee or trustee, a statement that the trust has not been revoked and remains in full force and effect, a legal description, although I usually put up with a shorthand version of that, of the property to be sold, and then at least enough of the trust powers set forth in the memorandum showing the trustee has the power of sale. You need to know that you're going to have to get your hands on that trust or get a memorandum of trust recorded. Then when you look at the trust, you want to make sure they in fact do have the power of sale and that there's no strings attached. Sometimes there are. And then you have to watch. Sometimes the trustee lives far away and the trustee says, well, I can't come to the closing. I will give my realtor or someone my power of attorney. You can't do that. That person is acting in a fiduciary capacity, looking out for someone else's interest. They're not supposed to delegate that authority to someone else. Okay. Sometimes, the deed itself, the deed will often be to the trust, but sometimes it's to the trustee of the trust. That's good. But when we go to closing, when we prepare that deed, the deed will be from John Smith, trustee of the Mary Smith Trust. In other words, the trustee is listed as a grantor, and the trustee is who signs the deed. We take it to the courthouse like any other deed and record it, and then you're fine. But you have to be aware of all 3 of these problem areas that we see all the time here. People trying to sell off a tax sale, people trying to use a power of attorney, people selling out of a trust. One other thing on trust. Kim is here with me, and I'm sure she would agree with me that it's amazing how uninformed many trustees are when they come to see us. They have no clue what they're doing. They never bothered to go get a federal tax ID number from the IRS, which takes 10 minutes, 5 minutes on a computer. They've never set up the trust with its own checking account, nothing. They just think they can come in and sell the property, sign their name. We're going to write them a check, and we're going to trust them to do whatever the trust says they're supposed to do. Believe me, it's not like that. And we get them in here all the time. They get hostile with us. They just can't understand that, hey, we didn't do this. Your mom and dad set up this trust or in the will. They didn't leave it to you outright. They left it in this trust. You're the trustee. You have to do it that way. So you need to be aware of that if you even hear the word trust, put your deflector shields out and say, why does this person talk to me like they're going to do all this? I want to see that trust and see they have the power. All right, those are the 3 areas. And I'm going to open this up. I'm not sure, where do I stand on my time now?
It's only 12:26, so you have another half an hour. And
well,
like I said, they can unmute themselves to ask a question, or they can type their question in the chat box.
They can unmute themselves. I don't mind that I have half an hour. I typically, when I go over these 3 topics, usually a lot of questions arise. So that doesn't fine. We can answer all their questions. Now, if you want to unmute and tell me who you are and talk to me, I know most of you, and I can say hello.
One thing that Bob did not say, it should be a given, but I just want to remind you on a power of attorney, if they are not over the age of 18, they cannot sign a power of attorney. I had someone present one to me that was signed by a 7-year-old. So just want you to be aware.
I want y'all to know these 3 things that we're telling you here. You might think, well, these are 3 things that will never affect me. I assure you that in the modern world, with an aging America, etc., we run into these 3 sets of circumstances a lot. You want to know about them going in. You want to know about them so you can provide for it in your contract. You don't want to wait till you get right up to closing and find out that someone who has to sign your deed is in jail or whatever. You need to find out all this going in. You can provide for it. Most of these things, by the time you get up to closing, can be resolved. Even court judges will usually give you an expedited hearing. When there's property just sitting there, you don't want people cooking meth in it or something, they'll usually expedite the process to help you. But you need to know this going in so you can start getting ready to resolve these issues and these problems. Okay, I'll take questions now. None?
Well, I think they should be able to unmute themselves. You can hold down the space bar to unmute yourself. Okay. Let's try it this way. I'm going to ask them to unmute. I can see
Dean, I can see Penny, I can see Amy. So I know they're listening to me anyway. That's the 3 that show on my phone. I don't know if anybody's trying to ask a question, but I'm here if you want to. If you have to type it in, that's fine.
Hello, can you hear me?
Yes.
Hi, this is Debbie. I'm on my phone, so you can't see me. I'm with Whitetail Properties, and I'm actually in Illinois listening to you right now.
Okay.
On the tax sale properties, you were talking about lenders wanting title insurance on their property, or when they're going to make a loan, which everyone does. And you said there were 3 ways to accomplish that. And I'm typing notes here for my agent as you were talking. And so the first way was to get a quitclaim deed from the owner. The second way was the quiet title lawsuit, but I missed the 3rd option, or the 3rd way that you could accomplish a sale like that.
The 3rd way is simply to let the title attorney and then the lender understand and prove that the deed from the auditor or county clerk, whatever, is at least 3 years ago. That's the 3rd way. If the 3 years have run, the court will no longer entertain a suit to set it aside, and you're fine. If That's the three ways. Wait the 3 years, go to court, or
Okay.
get a quitclaim deed.
Okay, all right, thank
Okay.
you.
I had someone from a friend of mine from one of the title companies we write for tell me that one time they had one where it was in the 3 years, and someone came and moved and tried to get the thing set aside, and the judge told him in chambers, said, look, I'm going to let him do it. I'm going to set the sale aside, but I want you to know that from a practical point of view, you pretty much pushed all the buttons. It looks to me like you gave notice, you did this, but I just can't bring myself. This was an elderly lady who said she didn't understand when she got the certified letters telling her she was going to lose her property. Said, I just can't let this happen. And we feel that's how most of them look. They look at that big check that person has to write to redeem and pay all the court costs and pay legal, all this that goes into it. It can be expensive. And they feel that the person has been punished enough. Usually they don't go so far as to congratulate you on how you did such a great job, but they're going to set it aside anyway. But we think that's what most of them are thinking. But I can tell you that judges are just very prone to set these aside, and about the only safe way is to either get the quitclaim deed or go do the suit to quiet title, or you're going to win the suit to quiet title, because that same judge may say, no, I don't want to do this. This person might want to set this aside or whatever, or let the 3 years pass. They're very problematic. West Virginia, there's even some law in our state that's kind of vague, and our Supreme Court of Appeals hasn't really spoken to it, but there's some law that says that even if you have a right that springs up, something happened as a precondition to your having an interest in this property, even if the 3 years have gone, you can come in years after that and maybe move to set it aside. That's what caused it in Michigan. There was a case where someone, it had been 20 years, they had some way they claimed they were outside the 3 years but could still bring the suit. And a court in Michigan set one aside, and the Michigan bar just said, we've had it. Don't certify them until 20 years goes by. We're not that bad in West Virginia, but they are definitely very, very difficult to deal with, very dangerous, and ones that you'll want to be aware of when someone approaches you with property out of a tax sale. Next question.
Hey Bob, this is Kim Chaffin at Real Estate Central. How you doing?
Fine. How are you?
Good. My question is, how does an estate work? I mean, you're not in a trust or anything. It's just, you're the executor, executrix. What is there anything there we need to be looking?
Yeah, those can be not nearly as tough. The ones that we run into all the time where there's a lot of misunderstanding. First of all, when someone comes to you and tells you they want to sell out of an estate, ask to see the will, see if they really are the executor or the executrix, and if in fact they have the power of sale. If there was no will, it's called the administrator or administratrix, they never have the power of sale. It has to be in the will. Quite often too, though, it's not that at all. They say they're selling out of an estate, but they're just, let's say, 3 grown kids, and mom and dad died, and mom got it, and mom died, and her will left it to the 3, but the other 2 maybe live far away or something. They're depending on the 3rd one who has gone down and has got appointed and is settling the estate. But many, many people think that by doing that, they have the power of sale because they're settling the estate. They do not usually. It's all 3 of them. They were left it in the will. And so that's why when you go into that, you'll want to take a good hard look at the circumstances. Is there a will? If there is, you want to look at it and see, is this person who's trying to sign this listing and this contract with you saying they have the power to sell this property out of this estate, do they really have that? The other thing you'll be aware of is often the estate, the person has not been deceased very long. Doesn't mean there's greed or anything operating. They just know that it's not good to let property just sit there. But often, shortly after death, people come to you and say, we want to sell. Mom passed away. It's our property, whatever. You need to be aware that not only you need to look at it, you need to look at the estate, but you also need to be aware that any claim that's filed against an estate, maybe the ambulance wasn't paid, the funeral home wasn't paid, the crematorium wasn't paid, they got a new transmission 3 weeks before they died and hadn't paid for it, or blah, 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 goes on, credit card debt or whatever. Maybe there's all kinds of claims filed against the estate. That's why you see those ads in the paper telling you if you have a claim, file it. There's a statutory period. So even after the appraisement is filed and the ad runs in the paper, you're going to have a statutory period, can be 2 or 3 months or more, for claims to be filed. So you need to be aware of that too, because quite often when we do the title examination, we will find that the person is on solid ground. They do have the right to sell it. They are the executrix, or they are the people that was left the property under the will. They're doing it and they're fine, except that enough time hasn't passed. There are claims that haven't been paid yet, or there might be more claims filed against the estate. So then we have to, and you all know how, I'm sure all of you here and me have done this, that's when you have to escrow. That's when we have to hold the money back, and we tell them we can't pay, we'll close. But until that period runs and you file the final settlement of that estate, so that we know there will be no further claims made against the estate, till you do that, we're going to hold this money in escrow. So that's the way we get around that. So when you get one, I always tell all realtors, hey, don't hesitate to call me. It's okay, I'll have permission. They know I say this. They tell them the same thing. If we're not your person, then if it's Mark Slotnick or it's somebody else, call that person, call that lawyer. We want you to. We'd rather know it going in as way down closing. Hey, Bob, I've been approached. Want to read you this out of the will. Do they have the power of sale, etc.? At least acquaint yourself enough to know what you're getting into, because it's very easy on an estate to get down the line somewhere, and then finally we look at the title and tell you there's going to be delay, or this person doesn't have it, or there's claims against the estate, there's state tax liens, IRS liens, all kinds of things that have to be paid. So you need to kind of get yourself up to speed on that going in. But sales out of estate are very common, either by the person selling the estate or the people who were left the property in the estate. So don't be scared off by that, but just get the facts going in so that you don't get right up on closing and then find that, oops, this person is settling the estate, but they don't have the power to sell this. There's three grown children, and they were all left this property, and I can get 2 of them to sign that deed, but daggone it, that third one is deployed. That third one is overseas with the military. You got a problem. Those are the kind of things you want to think about when someone says it's coming out of an estate. Okay?
Thank you. I appreciate it. And I just want to say you have a gem in Ian. He is amazing and so helpful when you're at the courthouse and needing to find something and can't find it. So he's awesome.
Absolutely true. We have a lot of confidence in him, and it is comforting to know that he's on our team, and he's really good. Our other abstractors that we use in other counties are excellent the same way, and it's wonderful to know. I can tell you a story. I went over to the fiduciary supervisor's office not too long ago. Then we were going to file some documents, and Ian had to stay outside for a minute on his cell phone. So I walked into the fiduciary supervisor's office and tell them I just need a moment with someone to do this and ask them a question. They told me to go sit over on the chairs with everybody else and wait till they could take me. And I go over to wait, and Ian happens to stroll in, and they said, "Wait, are you with Ian?" Well, then they just took us right on back, and we got what we needed, and I got out of there. That tells you that a lot of people feel that way about Ian. He's first class. I'll tell him I'll tell him that his work is appreciated by more than just us here at the office. Any other questions?
Yes, you do have one question. What is the statutory period for filing claims?
It's, I'm embarrassed to say, I can't remember if it's either 60 or 90 days. It's 90.
90 days
90.
past the date of the filing of the estate
Correct. The
appraisement.
appraisement.
Not the date of death, but
No.
when they start the appraisement.
Yes, I say that because it is 90 days after the appraisement, and you also have to file. They won't even start counting usually until you file. Also, till they file the ad in the paper, and they tend not to do that until you file the appraisement. That's why it's kind of confusing. But the appraisement is just what it sounds like. It's not an appraisal. You don't have to be an expert on valuing mom's antique brooch, but you have to list it. It's worth something. It's an appraisement. It's a listing of the assets of the estate: money, personal property, stocks, bonds, and real estate, and a listing of who the person who's filing it says is entitled to this property, who the will left it to, or who the heirs are if there's no will. You file that, and when you do that, it starts the clock running, and they have 90 days to file. And again, by code, anybody who files a claim against the estate, the amount of that claim becomes a lien against any real estate in the estate, a lien. So it has to be taken care of, or if there are none or whatever, you wait until the time runs, you know if there are any or how many there are, those have to be taken care of and released to make the title good on the property. So that's critical. And you get people who go over and get appointed, they think they're done. They don't do anything else. They don't file the appraisement. So they never start the time running, and they come and we get the title and we have to give them the bad news. You haven't done anything. You have to file that appraisement. You have to wait, blah, blah, blah. And then we're still going to probably wind up escrowing the money until you finish settling the estate. So the sooner, if someone comes to you and tells them they're settling an estate, make sure they're actually settling it and they're actually doing what the fiduciary supervisor's office is telling them to do. Otherwise, you're not getting that time running. Any other questions?
I don't have a question, Bob, but thank you for doing this. This has been helpful information. Some of it I had, but might have been a little confused on, and so this was helpful.
Yeah, I want to say again that been doing this now with realtors and going around for about 2 years. Mark has really been traipsing around Slotnick, trying to talk to everybody about identity theft and hacking and all the stuff we all put up with. He's really great on that, and I sort of took this part of it, and I've been trying for a couple years now to get the word to realtors that the biggest thing you can do to make sure on the other end of the process that you do have a smooth closing and everything's there and everybody gets paid and commissions are paid. The really critical time on all that is really going in. When you first are approached by that person, if you will just take a little extra time before you put it under contract or list, whatever, and do what we're telling you to do. See if there is a power of attorney. See if the estate is being settled. It's easy to do. Check and see on this or that. If you'll just do these things rather than get into it, and then we do the title and we find out, hey, you got to do this, you got to do that, and then your closing is delayed or made much more difficult, you'll be doing yourself a really big favor. I know we all, human nature being what it is, we're really busy. We're trying to get a contract signed, and then we think we're going to follow up and look at some of these things. We've been busy on the other things. It's very easy to do, but I'm telling you, you don't know how often we've had people go in early and look, and sure enough, they found that someone was in the military. We made sure that they had went to see their legal affairs officer before they were deployed. We got a power of attorney. We find there's this, we find there's that. It's a good thing we found it because we were able to go on, get on it right away. Quite another thing often we find is you get into it and you find that, gosh, it sure looks like the guy might have built his driveway slightly over on the neighbor's property. Do we need a survey? We run into this all the time. If you think there is, you need to check on it and find out and maybe take some action on that, because when we get into it, we will find out and then we'll put one of our requirements, an accurate survey of the property, and you don't want to find that out, and we would let you know ahead of time, but you don't want to find that out at the last minute. So that's really the message I've been carrying around to realtors all over the place for the last couple of years now, is we've seen this over and over. Just don't hesitate to ask these questions. So usually these people volunteer. They're very proud of the fact that they're there listening, and boy, I'm settling mom's estate, or I've got this power of attorney, and they'll usually volunteer that, and that's when you just pick right up on it and say, hey, I want to see that. I want to verify that, or whatever. You don't have to say, use the word verify. It'll sound like you don't believe them, but you know what I mean. And just look at it going in. It will can save you a world of trouble way down the line when we're trying to close and we find we have an issue. And we've hit all of them now today. These are the big ones: sales from estates, tax sales, powers of attorney, trust. Those are the things we run into here constantly, where somebody is going along and then we get into it and we find out there's an issue. Sometimes it's easily fixable, sometimes it's not. The sooner we know about it, the sooner you know about it, the sooner we can roll up our sleeves and try to fix it, which we are glad to try to do when we need to. But the sooner you know, the sooner we can start working on it, okay? Any other questions?
Yes, you have a question. They want to know, is it required for everyone to do probate in West Virginia?
Well, that is a great question. The answer is theoretically yes, but as a practical matter, no. For instance, there are some people who all they have in the world is they have a house and they own it jointly with their spouse, let's say. And they don't have much of else. They've got Social Security, which will stop, or probably stop when they die. They might have a modest checking account somewhere. Again, that's joint checking. Theoretically, title is passed under survivorship, etc. You would still need to file a death certificate or whatever to prove the person died and it moved by survivorship. But in the overwhelming majority of times, you should have a will and it should be probated. If you're young, your will allows you to say who you want to be named as guardian of your children. If both of you get killed together or whatever, you can say that in your will. That alone is enough. Secondly, in your will, you can put provisions that whoever's settling your estate does not have to post bond. That saves you more money than you spend at the lawyer's office getting a will right there. But yes, you should probate for all the reasons we've said, because if there's property in there, you need to file that appraisement. You need to give people a chance to file claims against the estate. You need to do those things to go through probate if you want to have clear title. So in most cases, yes, you should probate, and it makes that probate process a heck of a lot easier if you have a will. Any other questions? Another issue that if I've got do I have a few more minutes?
Yes, you have 10 minutes.
Okay, another issue that comes up a lot with us is West Virginia, like most states, has an excise tax. You've probably run into this terrible thing. Tuna has an excise tax on non-residents who sell real estate here in West Virginia. Most states have that. They love it because they can tax someone who lives in another state and doesn't vote here. So even if that person gets furious, they can't take it out at the ballot box. Most states have this now. West Virginia has it. We hate it. It's made us a unpaid tax collector for the state, but we are required to retain 2.5% of the proceeds that goes to a non-resident. If you have 4 grown adults who've just inherited property and 3 of them live here and 1 live in Charlotte, guess what? The one in Charlotte is going to have 2.5% of their share kept by us. We have to send it off as a withholding tax. It doesn't mean necessarily they're going to pay it. They can actually file papers. We usually provide them the papers here at the closing. They can usually file and often show they don't owe it, but they might. It's 2.5% of their gain. Fortunately, we most often see this in estates. And like Kim told you, you have to file an appraisement, and on that appraisement, you value the property, and you're allowed to use the value of the property as the basis for the property. So if someone dies and you value the property correctly at, let's say, $100,000, most people value it a little bit low. They think they have to pay inheritance tax, but we don't have any in West Virginia. But let's say they valued it $100,000, and you sell it for $110,000. We have to take 2.5% of that 1/4 of that person who lives in Charlotte and send it in, but they are then allowed to show the state that, hey, the basis in this was $100,000. We sold it for $110,000. My 1/4 was only $2,500, not 1/4 of $110,000. So quite often they do not owe much. Sometimes they don't owe anything, but at least up front, we have to withhold that and send it in. It, of course, makes people furious, and usually they're mad at us because we're the ones that have to send it in for them. But that is something you might be aware of. If you have out-of-state sellers, you might alert them to that fact because they're going to find out about it sooner or later, and they're usually not real happy about it. Often they don't know, as I said, but we have to at least at the closing collect it. One of the things you get, though, is when the will gives the person selling the estate the power of sale. We love that when it's in there. The person, the executor, executrix, is specifically in the power, given the power to sell the real estate and divide the proceeds. We like that because now all 4 of them don't have to sign the deed, only the person settling the estate, and we're allowed to make the check to the estate of John Doe. And guess what? It's not our problem when they divide it. It's not our job then to collect the 2.5%. We don't know whether it gets sent in or not, and we don't have to worry about it, and neither do you, by the way. It's the estate is the owner, not the individual that lives in Charlotte. And so we get out of that. So we like it. We like it when it's a probated estate, and the person who's settling the estate, the time is run, they've done it all right, and they have the power of sale. We like that. So if you read a will and you see that, you're probably going to have an easier time than sometimes you will than if a will just leaves the property to children. Because if there's, now, I don't have to tell you too, you run into airship. Sometimes the will leave it to those 4 children, grown children I was just telling you about, and then before you can get far along, daggone if one of the kids doesn't have a car wreck and gets killed. And now their 1/4 is going down to their kids. You might have 2 or 3 kids, grandkids of the person who died, and guess what? Maybe 1 or more of those kids is not an adult. Now you find yourself in court getting a court order to sell. So there's a lot of ramifications on this. I think you see what I'm saying. The more you know about all this going in and you tell us, the quicker we can begin to respond to that. and try to solve anything that needs solved. Some of these problems I've told you about, if they don't raise their ugly head and we do the title and you're trying to move toward closing, it's tough. I mean, it can be really tough to solve some of these quickly.
All right, we have one final question. You have 5 minutes left.
Okay.
It says if one never did probate and eventually the spouse sells the house, would it be a problem? The estate does not owe any creditors.
Well, it depends. If you never probated anything, but you did file a death certificate, and John Doe died, and John and Mary owned it. I'm glad I'm talking to realtors here. You'll understand this. When a lot of people wouldn't know what I'm talking about. If they owned it as joint tenants with the right of survivorship, like couples almost always do. When John died, it would have passed to Mary by survivorship. She then could probably, not talking about any other assets in the estate or anything it might be due and owing, anything, she would get title to the property through survivorship. However, if John owned it himself, maybe he inherited it from his family, maybe he and Mary owned it one half each. They weren't joint tenants. And then he died, and Mary thinks, I'm his wife. It goes to me automatically, blah, blah. No, that won't work. Then you'd have to probate the estate. But if it's joint tenants, typically when I'm doing a title, if I see two people own real estate and I know that I'm told he died, and I find his death certificate, and they owned it as joint tenants with right of survivorship, I know title is vested in the survivor, and we're okay. That's why people, lawyers, and I'm sure a lot of you all do too when you're asked, that's why we try to get people to own, couples to own property as joint tenants with right of survivorship. As a matter of fact, when we write a deed here for a couple, we make it joint tenants with right of survivorship unless they tell us otherwise. Because when you can, you should do it. Now, sometimes you can't do that. Sometimes you own your house that way, the survivorship. But then somebody in the marriage or in the relationship or whatever goes and gets some kind of property. It's just theirs. They want it to stay theirs. They don't want anybody else on that title. Then you don't have that. But typically, somebody's coming to you, people have died, they're selling the house, and if they own it as jointly, then if you're dealing with the surviving spouse, if they owned it jointly, then you're okay. Most of the time that's the case. But then at some point, that spouse dies. Let's say they get it and they don't come to you. You're thinking about it, but then they die. Now you're going to have to look at that estate because they don't have any survivorship. You know, the person that they were in survivorship with is predeceased then. And you'd have to look at the will or see what happened then.
Okay, that's the last of the questions.
Hey guys, as always, it's a pleasure. I wish I could be there with you in person and we could talk. You know, I liked it better, but at least we have this technology and I'm grateful for that. Real quickly, everybody here, Terry, Kim, me, you know us all. You've known most of us for a long, long time. We appreciate your business and we treasure our relationship with you. I hope I've helped you, not just from a professional point of view, from a personal point of view. I hope this has been helpful to you today, okay?
It was very informative, Bob. Thank you so much.
You're sure welcome. See you guys later. Next time I see you, hopefully we'll have checks for you. See you later.
Thank you. Bye-bye.